Please listen for your case, and I will indicate those cases which are designated for oral argument. The first case, People v. Mark Larimore. Are counsel present?
Yes, this is Victoria Wu on behalf of Appellant Mark Larimore.
And this is Ryan Foley on behalf of the people. Good afternoon.
Good afternoon. And the appellant gets 5 and 1, and the respondent will have 4 minutes for argument. Dimitriev versus City of New York. Are counsel present?
Yes, good afternoon. Brian Glass for petitioner Andrei Dimitriev.
Good afternoon, Your
Versus McGuire.
Paul Montori for the appellant cross-respondent, Your Honor. May I please request 3 minutes of rebuttal?
You were given 10 minutes, and what I will give you is 7 and 3.
Thank you, Your
So
Honor.
you can reserve 3 for rebuttal.
Jason Zakai for the respondents, cross appellants. May we have 2 minutes for rebuttal, please?
All right, so you can have 8 and 2. I'll split your 10 minutes time.
Thank you.
All right, you just have to make sure that Judge Maisonette knows. All right, People versus Joseph Pagan, that is a submit. People versus Clifton Samuel, that's a submit. Spielman versus 170 Broadway, are counsel present?
Yes, Your Honor.
Yes.
Okay, we have the appellant has 7 and 2. All right, we have 3 respondents on that. All right, and the respondent, 170 Broadway.
170 Broadway is the appellant, Your Honor, but we present.
I'm sorry, you're correct. All right, the respondent, we have well, we have 3 respondents, and you'll forgive me, my calendar doesn't fully address you. So the first respondent would be is who? Identify yourself.
Good afternoon, Your Honor. Yolanda Ayala for the respondent, cross appellant Colgate Enterprises. I request 6 and 2, please.
You were already given time. You were given 8.
Right, I want to know if
And
I
you're
can
a
change
cross
that to 6 and
appellant, 6-2.
6 and
Okay,
2.
thank you, counselors. We're making today as confusing as possible. Thank you. But 6 and 2 you have. Okay, next respondent.
Joanne Bell for McGowan. I had requested 7 minutes. Can I have 2 of those for rebuttal? So 5 and 2, please.
Are you a cross appellant?
I am. I'm a respondent and appellant.
Okay. We'll do a 5 and 2. All right.
Thank you.
And finally,
Mary Ellen O'Brien for respondent, Martino Construction. I request 3 minutes, Your Honor.
all right, you have 3 minutes. Okay. Amadolari versus Same, that's a submit. Haley versus ABB. Counsel, identify yourself, please.
Good afternoon, Your Honor. Andrew F. Bain from McElroy, Deutsch, Mulvaney & Carpenter for defendant appellant. And I'm virtually accompanied by Stephanie Eaton, who a member of the Bar of North Carolina, who was admitted pro hoc, and I respectfully request that she be allowed to participate.
All right, so she'll be doing the argument, and she has 7 and 3.
Thank you, Your Honor.
All right, respondent.
Good afternoon, Your Honor. Andrew Grouse of Walens, Goldman and Spitzer for plaintiff respondent Helen Haley.
And you have 8 minutes.
Thank you, Your Honor.
People versus Della Tacoma is a submit. Derek G versus Alice M is a submit. Subway Real versus Salim is a submit. People versus Hamby is a submit. Kamara versus Afaya is a submit. Friedfeld versus Citibank is a submit. People versus Michael Flanders is a submit. Perez Vargas versus Aaron.
Good afternoon, Your Honor. Richard C. Bell for Plaintiff Appellant.
And Paul Lima from Sobel Pevsner for Respondent. Good afternoon, Your Honor.
Good afternoon. And the appellant has 5 and 3, and the respondent 5. People versus Louis Sierra, that's a submit. Magukin versus Bereshai, that's a submit. And Hoppenstein versus Hoppenstein, that's a submit. And that concludes the call of the calendar. Do we have an update on?
I can hear.
Okay.
I just don't believe I am visual yet. Am I correct?
That's correct. That's correct.
Okay. Judge Gish, are you on live?
I am on, we're on live, yes.
So I'm saying, can they see you?
Yes, they can.
Fantastic. Why don't you continue calling the calendar then, since I am blind, as it were?
Okay, all right.
Okay.
I'll keep the time too. I'm also going to ask the clerk, Ms. Rojas, because there's been some adjustments of the time in terms of rebuttal, if we could just make that information available to Judge Mezinet when she finally is able to otherwise get
I
her.
did hear, I did hear all the updates. Thank you.
Okay, great. All right, so the first case is People v. Mark Larimore. I'm going to remind all counsel who are not arguing to please put yourself on mute.
Good afternoon, Your Honors. Victoria Wu, Office of the Appellate Defender, on behalf of Mark Larimore. The record in this case demonstrates that Mark's term of 23 years of imprisonment should be reduced in the interest of justice. Indeed, this court has modified the sentences of other teenagers in recent similar cases as this one. Over the years, there has been a paradigm shift in juvenile justice in New York.
Counsel, I have a question.
Yes.
I understand that the remand was solely for the purpose of considering the YO, not otherwise for a reduction in sentence, correct?
Because this court in its prior decision vacated a sentence, the judge had to make a determination on the appropriate sentence in the event that YO was denied.
So you're saying that if we deny, that he, upon denying YO, he had the authority to modify the sentence?
No.
Okay, but if he denied YO, then the sentence remained in place, correct?
Well, because he had to reimpose the sentence that he deemed appropriate, yeah.
Okay. Now, I know he don't, I'm sorry. Go ahead, Judge Gish.
Just that my understanding was when the trial court got this, the sentence was vacated, but he felt that he could determine YO, he couldn't determine the sentence because that was part of a plea negotiation. Wasn't that? And the defense conceded that. They said, yes, that's true. But the issue of excessiveness, the excessiveness of the negotiated plea in the interest of justice, which we have jurisdiction to look at, you believe is still open.
It is, because this court has the discretion, it has the power to reduce a sentence in the interest of justice, even if it was a negotiated sentence. There are numerous cases that in which this case has exercised that power. And in this case, this would be an appropriate one to do so.
Counselor, this is Judge Singh. So these are the facts. Your client approaches a 34-year-old man, shoots him 5 times, and he's pronounced dead. Why on these facts would it be appropriate for us to exercise our interest of justice jurisdiction?
Your Honor, there's no question that the incident was very serious, but you also have to
more than serious.
Context. I'm sorry?
It resulted in death. I mean, it's more than serious.
It did result in death, but in similar cases, this court has reduced the teenagers who were convicted of homicides. Recent decisions, for example, such as People versus Castillo.
But on similar facts where there's a man lying asleep on a bench, at a bus stop, and he's just unprovoked. He's shot really 6 times, 5 by your client and 1 by the co-defendant?
Again, there's no question that the incident was serious, but I would ask that you consider Mark's life both before and after the incident. Mark was only 17 years old. He was involved in this incident under the influence of an older peer, Sean White, whom he regarded as an older brother. At that age, of course, his brain was still developing and maturing. His ability to appreciate and evaluate the consequences of his actions were not fully formed.
Well, the co-defendant was only 19, true?
Yes. But, you know,
And when you talk about the influence that he was under from Mr. White, I looked in your papers and I didn't see anything apart from an assertion that he was under the influence of Mr. White. I didn't see that there was any way that, I didn't see any description of what that relationship consisted of that would cause Mr. Laramore's will to be overborne in some way.
It's not that his will was overborne, but there is, in the pre-sentencing memorandum that we submitted to the resentencing court, Mark did indicate that he looked to Sean White as an older brother. At sentencing, on pages 22 and 23 of the sentencing minutes, the decedent's former wife urged Mark to be not a follower, those are her words, because in her words, falling has brought you here, falling has made you choose to make bad decisions. So it's clear on this record that Mark was under the influence of an older person who he regarded as an older brother.
I don't think that's fair from the victim's family's statement to draw that broad conclusion. The victim's family didn't even know your client or anything about your client until he, in a most violent way, interjected himself into their lives.
Well, I mean, that is only one factor, Your Honor, in a record that contains extensive mitigation. This record also includes, facts about who Mark has become in the 11 years since this incident has happened. I will draw this court's attention to a letter written by Sean Johnson, who works with the Council for Unity program, who has worked with prisoners for 16 years. He describes Mark as truly a standout individual, one who is sensitive to the feelings of others. He has a desire to put himself in other people's shoes. And all this demonstrates that Mark—
Yeah, I'm going to ask you to finish your argument because you've already exceeded your time. So wrap up your thought, please.
Yeah, so in sum, considering Mark's vulnerabilities at his young age, the promise that he has shown since the incident more than 11 years ago, I would ask that this court reduce his sentence in the interest of justice.
Thank you. Respondent?
Good afternoon, and may it please the court, Ryan Foley for the people. This court should affirm the judgment of resentence for 2 reasons. First, the defendant does not deserve YO, and the court below providently—
Counsel, I have a question. Do you agree with defense counsel that we have interest of justice jurisdiction to just reduce his sentence regardless of, even if we deny his application for YO?
Your Honor, I disagree with that, but I'm happy to address the merits. Our brief articulated the reasons why we do not believe that this court has the discretion to adjudicate defendant a YO or reduce his sentence any further. This matter was conceded by the people, and it's in the first appeal as a violation of People v. Rudolph. It went down for the express determination of a YO finding. The court denied it properly, and so it's coming back up to this court on that issue alone. But I'm happy to address.
Yeah, doesn't it matter that we vacated the pleas? I mean, the sentence. So the sentence, not the plea, the sentence. So the sentence had to be reimposed, and we never looked at it. We never examined it in the interest of justice, did we? Even on the first appeal?
No, Your Honor. It was strictly on the Rudolph error. So to that point, I will address the merits. This was an extensively negotiated plea. Not just one defense attorney, but 2 defense attorneys reviewed it and encouraged defendant to take it, largely because both attorneys saw the strength the overwhelming strength of the people's case, the fact that there really was no viable defense, and it's
Counselor,
here
this
before
is
the
Judge Singh. What about your adversary's arguments that we should take into account his age, probably lack of impulse control, and really now sort of the good behavior that has been exercised for the past few years in making that determination?
So 2 points on that, Your Honor. First off, this was a 17-year-old defendant. This is the cases on which defense relies in their brief really are not talking about the types of youthful indiscretion of walking up and point blank executing a sleeping man on a park bench with no provocation. I think, as Your Honor correctly pointed out, the cases that defense relies upon are not talking about facts anywhere similar to this. It's 17 years old is certainly old enough to appreciate the consequence of doing what he did. But I do want to spend a moment addressing the arguments of what defendant has done post-conviction. I don't think that should factor into this court's calculus at all. It really, in exercising your interest of justice jurisdiction, it really should be the sentence at the time it was imposed. Was it fair? And in light of the facts of the case, what defendant is advancing before this court would be more properly submitted in the form of a clemency application to the governor. It really shouldn't matter what he's done in prison since the crime. What matters is that he brutally executed a man. He has really no mitigating factors on this record, certainly none of which are articulated in his brief that would at least outweigh the gravity and the brutality of this crime. It was horrendous. So with that, we would ask this court to reaffirm the judgment of resentence. And if Your Honors have no further questions, the people will rest on our brief.
Thank you.
Thank you.
Mr. Wu?
Just very quickly, Your Honors. So this court has both the jurisdiction to reduce the sentence upon an appeal from a resentencing, and also the authority to consider the conduct of the defendant after the initial sentencing. This court's decisions in...
Excuse me, what gives us the authority to consider his post-sentence behavior? It seems to me that we really have to consider whether or not it was excessive at the time it was issued. It was of the sentence.
So in People versus Castillo, this court did precisely that. This was a case where, on a similar posture, they were sent back for a YO determination. A sentence was imposed anew, and on appeal, this court reduced the sentence of the teenager defendant in part based on his conduct after the initial sentencing. There are several other cases I cite in my reply brief on pages 7 and 8 in which the exact same thing happened. Cases sent back for YO determination, it goes back up to this court on appeal, and this court considers all the information in the record to make an appropriate determination. And I think those cases also underscore that despite the seriousness of the incident, it is appropriate to consider.
Counsel, this is Judge Singh. What about your adversary's point that this was a heavily negotiated sentence? There were two counsel for the defendant. Under those circumstances, why should we upset that negotiation?
For two reasons. One is that it was negotiated before the current modern understanding of juvenile justice. There has been a shift in perspective, and even the resentencing court judge acknowledged that at resentencing. He noted that there is a different perspective today on juvenile justice than there was at the time of the negotiation. And the second reason is, of course, we now have information about how Mark has conducted his life. The parties at the time of the negotiation did not know that he would become a mature and thoughtful adult, a mature and thoughtful adult like he is today. So in light of the intervening changes that have happened over the years, it is imperative to adjust the sentence accordingly. For that reason, I would ask that this will reduce the sentence in the interest of justice. Thank you so much.
Okay, thank you. Right, the next case is Dmitriev versus City of New York. Step up.
Good afternoon. This is Brian Glass for former New York City tenured teacher Andrei Dmitriev. As the court is aware, I've argued a number of these tenured teacher 3028 decisions in front of this court, and I do recognize that the Bolt standard has made this somewhat difficult. But 2 days after Bolt, this court issued a decision in Dukovsky, which had the issue about whether the conduct itself was actually misconduct. And I think this case raises the question about whether Mr. Dmitriev's actions in this case were even misconduct. Here we have
Isn't the issue here inaction rather than the action? Isn't that what the real problem in this case was?
Yeah, and the board is charging that as misconduct, but if you put yourself in Mr. Dukovsky's shoes in this moment, in the heat of a moment where he's out in a park with 40 high school students and there's a stabbing, and his decision is to get them to stop and try to come back to the school as quickly as possible.
Okay, but I'm sorry.
Isn't part of the problem that your client wasn't even aware that there was a stabbing, because notwithstanding seeing an altercation between two students, he did not bother to go over and check with either student to make sure they were both okay?
Well, again, he's got 50 students in a park, and I guess his initial reaction was to get them back to the school. I think the arbitrator did not find him guilty of not taking action because of the stabbing. He did find out about that later. I think his immediate reaction was to get back to the school as fast as possible. And so, there's no clear standard that there was a violation of any specific regulation from the chancellor at this point.
I'm a little confused, though, because my understanding is that your appeal is limited to the harshness of the penalty and not to the findings that the specifications that were otherwise found against your client.
Well, I do think these concepts meld together. I mean, we've had several cases from this court, Poles and Dukovsky, where these were tenured teachers who were terminated, and this court looked at it and decided that in their mind it wasn't even misconduct at all, or it was very questionable whether it was even misconduct, and for that basis they vacated the penalty. And Dukovsky and Poles.
Let me stop you there for a second. So as I understand the facts, a student came up to the teacher and said, "I was stabbed." And the teacher's alleged response was, "I don't care." So putting that aside, we go back to the school. Does the teacher then follow all the protocols necessary, filing incident reports, et cetera, in accordance with the school's guidelines?
Well, two things. I don't think he was, the student who was stabbed did not come up to him. There was a report from a third student who came up and said there was an altercation away from him, and he said, "Stop." When he did come back to the school, he did testify that he reported both to the principal as well as to the security guard on staff. And
he went to the security guard. There's no question about that. But that's all he did, right? Wasn't it the principal? Wasn't it then the security guard notifies the principal, and then the other folks brought down the incident report for the teacher to fill out? Isn't that more than action at that point?
Well, where is the misconduct there? I mean, I'm not exactly sure what he was to do different. It's not like he was hiding the incident or trying to keep it away from the school. One other point I want to make before my time runs out. This case was heard in unemployment. I represent him in unemployment forum, and the hearing officer in that case found that there wasn't misconduct under the unemployment standard. So again, the question in this kind of case is, what is the misconduct? Is there actual misconduct? Clearly there are in certain cases, a corporal punishment, but here you're just sort of clearly, you're not really defining it. And I think that's what Dukovsky, the inappropriate conduct was not sufficiently defined. And I thought that was the linchpin of that case.
Counsel, can you clarify? You say there was an employment hearing. Are you talking about for unemployment benefits?
Yes, after he was terminated.
So I'm sure you are not suggesting that, and with all due respect to whoever held the unemployment benefits hearing, that they are familiar with the Department of Education guidelines and policies so that their finding would somehow be binding on the Department of Education, do you?
No, I'm not suggesting that it's binding. I'm just suggesting after the fact, when a neutral looked at this and said, would this qualify as misconduct or New York State unemployment law, it would not qualify because there's sort of no deliberate action. And I think you can kind of import that concept in this case. I understand it's not collateral estoppel. It doesn't bind anyone on this panel. But I think it is interesting that as a neutral looked at this, said, I don't think this would be misconduct to disqualify someone from benefits under the law. And so it's not clear to Mr. Dmitriev that he violated anything specific. Perhaps he could have taken better action. He did show remorse. He felt terrible that this happened. He did try to show, that he wished he could have paid more attention. But even if, what was he supposed to do? Kind of just stare harder? It wasn't really clear what you're supposed to do in that kind of situation. There's no clear guidance. And is he going to put himself in the middle of two kids with knives? I mean, I don't think you'd expect.
Wasn't he supposed to have a radio and call in from the park if there was a problem? I mean, there is a protocol in place. He didn't follow the protocol. And the question is were students at risk as a result of not following the various protocols the school had implemented? Isn't that the issue?
Well, I'm not sure the protocol was so clearly defined here. I mean, he's taking two classes out to a park, and had he had a radio, I don't think he was deliberately not calling back on the radio. So I'm not exactly clear where the protocol broke down. In fact, I think they did cite one regulation in the 3028 decision, and the arbitrator agreed he did not violate that protocol and dismissed that charge. So there's really nothing here other than someone's, Monday morning quarterbacking to say, well, he could have done this, he could have done that. It's not clear what should he have done differently. Should he have gotten in the middle of a stab, two kids who were in a fight? Should he have stabbed? Should he have laid? It's not exactly clear under this record.
There were things he could have done. He could have separated the kids after the first altercation. I mean, he's charged with supervising them. So I understand, maybe for unemployment benefits, it doesn't count as misconduct, but in the arena of teaching, not appropriately supervising children. And I'll give it to you. He had too many kids. I don't know why the school let him go out with that many kids, a double class, and take them outside to a park. But I don't think that changes the finding that he didn't properly supervise these children and put them at risk.
So even if you agree with that, even if I agree with Your Honor that it could have been better, does that warrant termination of a 16-year career with no prior conduct and attempt to show remorse?
That's on the penalty. And as you've indicated, it's got to shock our conscience. I don't know. The Court of Appeals has really clipped back the wings of the lower courts in terms of having discretion on this. So I think it's a difficult hill for you.
I understand, but the question is, after both, is there, and two of those cases they got reversed were mine where this court had overturned it. So I understand the difficult hurdle, but I think there are still cases, they didn't shut down this kind of appeal completely. And this is one of those close ones where there really isn't a lot of misconduct in this case. So.
Yeah, understood. All right, we'll hear, unless my colleagues have any questions, we'll hear from the respondent. Okay.
Good afternoon, Your Honors. May it please the court, this is Melanie West for the respondent. I'd like to just start by drawing the court's attention to some of the arbitrator's fact-finding and credibility determinations that, as Your Honor pointed out, are not challenged in this appeal. So the arbitrator credited the bystander student's testimony that Mr. Dmitriev was on his phone with his headphones in, looking at his phone throughout the incident. That when the student approached him, Mr. Dmitriev did not look up and instead said, "I don't care, let's just get back to school." The arbitrator credited the student's account that he had blood on his shirt, pants, and hands when he approached Mr. Dmitriev. The arbitrator also credited multiple students' accounts that Mr. Dmitriev left students behind in the park and went back to the school. The arbitrator also credited the school safety officer's account that after stopping briefly at the desk and saying that there had been an altercation in the park, Mr. Dmitriev walked away as she called after him asking for more details. So
didn't he have a lot of the kids with him at that time? And didn't he have to bring the children to a safe spot within the school building?
He did have a lot of children in the park that day, and yes.
And with him when he was coming back, he escorted most of them back. Some of them apparently went awry. How many kids did you have with him that day?
I believe it was over 40, Your Honor. There were two classes that were combined.
And each class is usually about 40 kids, right? So you could have had 80.
I don't think that's right, Your Honor. I think it was about 50 students total. I apologize for not knowing the number. But absolutely, Your Honor, it was a large number of students. Another teacher had, I believe the school guidance counselor had offered to assist Mr. Dmitriev, and he declined.
But why was it up to Mr. Dmitriev? There was so many kids. How could anybody have expected that if something went awry and something did here, that he can control that many kids off school grounds?
Certainly.
Isn't it unreasonable?
Certainly, Your Honor. I will agree with you that the decision that one teacher would supervise that many students was not Mr. Dimitriev's failure alone. But that's not where the misjudgment stopped in this case, not even close. And what the arbitrator
I mean, doesn't the Board of Ed consider the impossible situation? I mean, it seems to be a situation like this that the Board of Ed has to take into account the total impossible situation it's on place this teacher in.
You can take it into account, Your Honor, but it doesn't change the many serious abdications of responsibility that took place after that moment. The arbitrator described them in some detail. First, after other students broke up an altercation, Mr. Dimitriev did not approach. He did not make an attempt to ensure that any students were. He did not try to keep them separated. He didn't even keep an eye on them. Then, had he done so, a second altercation probably would have been enough. Then, when the second altercation took place, he again did not approach them, did not try to make sure the students were unharmed. Then he left students behind in the park, including the student who had been stabbed. The testimony was that that student was escorted by other students back to the school who gave him something to cover his bleeding wound. He had his shirt off. Despite all of this, Mr. Dimitriev remained oblivious to the fact of the stabbing, which shows how much attention he was paying to what was going on. And that was yet another opportunity, had he escorted that his student had been stabbed and been able to take the appropriate measures, which he did not do, contacting emergency services and giving the details to the school safety officer. And there was also evidence in the record that he had been put on notice twice of the importance of vigilantly monitoring his students, once in 2008 with a letter to file, and once just a month before the incident, an email to him reminding him to closely monitor students and not leave them behind. Both of those communications warning him that it was serious and serious when the clue if he did not do so, as indeed they did here. And finally, the arbitrator also considered Mr. Dimitriev's total lack of insight after the fact into what had gone wrong. The only thing he expressed more was taking down the guidance counselor's offer to assist him in the park. He could not identify anything else he did wrong or would have done differently. And all of those things taken together amply justify the penalty in this case, which is far from conscience shocking. Your Honors, unless the court has any further questions for me, we'll rest on our.
Do my colleagues have any further questions? All right, we'll have rebuttal then.
Yeah, just briefly, even though the board goes into a million of these factors, if any of these things had done, he'd be watched closer. If he had done anything different, would have anything changed in this fact pattern? I mean, the stabbing was not something that he brought upon. It's not clear that even if he could have intervened.
Mr. Glass, this is the judge saying, your adversary points out that your client was more busy on his phone with headphones on as opposed to supervising the 50 to 80 kids there.
They're trying to create an image that he was completely cavalier to fit into this fact pattern. But the reality is, if you think about any of the actions, anything that happened in this case, what if any of his actions really mattered? Do we know? And even the arbitrator concluded.
Sure, they would have. I actually beg to differ. It was really unclear from the record whether the child who got stabbed was stabbed during the first or the second altercation. Some indication that it was the second. If it was the second and he had taken action after the first, the child might not have gotten hurt. And I think that's pretty significant.
I mean, the arbitrator eventually concluded that it was a contributory factor that could have maybe changed events. But again, I don't think it was, the evidence was that he completely ignored it, that he just, that he did nothing. He said, stop the fight. I didn't get the sense in this record that there's this complete ignoring and just saying, don't bother me. I think they're trying to portray that this way. But if you really look at the record, all the arbitrator could really conclude was that maybe something could have been different if he intervened.
Counsel, that finding, this is Judge Mansonet, that finding alone, how would this court then upset such a finding based on the precedent that we have to apply?
Well, even if you said he didn't take the perfect action here, then we fall into that second round, whether this is warranting a termination. And as I said, it's a one incident case. And again, the remorse, what is he supposed to say?
Is it a one incident case, Counselor? Didn't your adversary point out that, in fact, that there were 2 prior incidents where there were 2 prior warnings, a letter and an email? Isn't that something that also?
Well, first of all, that was not first of all, none of that was proven conduct. And it was simply just, he has a large gym class.
Warning, you got to supervise the kids.
It was a completely different context than being in a park. And what is supervising? You have 40 kids. I think there was one student had been in the hallway, and they said, you have to be careful in the future, just don't make sure the kid's in the hallway. It's a little bit different than being in a park with 40 students. So,
Counsel, this is Judge Gesmer. Whatever it may take to supervise 40 students, certainly wearing headphones and not looking at the students does not qualify as supervising students. And my experience of teenagers is they notice what the adults around them are doing, and the fact that he wasn't paying any attention would certainly have an effect on their behavior. Wouldn't you agree with that?
He disputed that he wore the headphones. I can't dispute that was what in the record he said he didn't do it. But even if he did, that doesn't mean he completely neglected them, and he was still in the park, and he did get the kids back. So I recognize that, yes, there are decisions he made. I don't think it would have stopped the stabbing. I don't think, in fact, the principal was not, there was evidence in the record that the principal didn't report anything either when he came back to the school, and there was no discipline against the principal. So part is they're saying, what was he supposed to report after the fact? He told the principal didn't do anything about it either and suffered no discipline. So he's a 16-year ATR where they're making the fall person, and I've seen this before with the Department of Education. Someone wants to be the fall person, they're pointing it at him. But obviously, there's a lot of contributing factors in this instance, and to end someone's career over this is extremely harsh. So I would ask that the court consider a lesser penalty, even if they do believe some of his actions would warrant misconduct, again, which is not defined in this situation. It really isn't. It's a judgment call that the board is making.
Thank you. Thank both counselors.
Thank you, Your Honor.
All right, the next case, Board of Managers versus McGuire.
Good afternoon, Your Honor. May it please the court, Paul Montori for the plaintiffs and appellants cross respondents. Your Honor, focusing on the pure legal narrow question in this case turns on straightforward principles of statutory interpretation. The trial court erred as a matter of law in finding that the business corporation law indemnification provisions applied to the appellant's unincorporated condominium. And that result has an application of the business corporation law that I submit was never intended by the legislature, and one that represents a significant expansion of the BCL with broad and unintended consequences.
Counsel, this is Judge Singh. Your adversary in his brief relies on First Department case, Sui versus Choi, and also a Second Department case. Are those cases a basis for us to affirm?
No, they're not, Your Honor. And that's because the Sui case never applied the substantive provisions of the BCL indemnification laws to the unincorporated condominium. It was a common law right, and that's consistent throughout the cases, a common law right that was actually applied to the unincorporated condominium. The indemnification provision in that case was used as a reference point to show that there was some similarity between the derivative action in the condominium context and the corporation context, the co-op context.
Do we know in the Tui case whether the condominium was incorporated or not?
We believe it was an unincorporated condominium, but the derivative action was the same. And the case, I think, Your Honors, that's really on point is the Carper versus Nussbaum case, and that's from the Second Department, which really, I think, synthesizes a lot of what Sui is talking about in some of the other cases. In the Carper versus Nussbaum case, the Second Department found that the RPL was silent with respect to derivative actions. Now, if the trial court and the respondents were correct, that would have been the end of the determination, and the BCL would have automatically applied. But that's precisely not what the Second Department did in Carper. What the Second Department did is specifically find that the BCL was not applicable to the condominium, and the condominium was not governed by the BCL, and then turns to common law principles to find what the derivative action actually entailed within the context of the unincorporated condominium. And that is true in other cases as well. And that's really what Sui was talking about. Sui was just looking as an analog to a principle of certain similarities between the condominium and the co-op.
Well, it's a little cryptic, and mea culpa, I was on the panel. It's just one sentence in the decision, and the reference to the BCL is at Seaside, I believe, no?
Yeah, that's correct.
Yeah.
That's correct, Your Honor. And I think the principle that really encapsulates it is looking at the function of what BCL 626E actually does. And we cite in our brief to the Motherway case, which I think really drives home a lot of these points as well. 626E was never intended as an indemnification statute. 626E only benefits the plaintiff of a derivative action when the corporation itself benefits. It's simply not an indemnification statute. So if the respondent was correct, in SUI, what we'd actually would be seeing is the defendant and the plaintiff both asking for indemnification. And that's, of course, not what happened, and that's not what this court found. So in that respect, I believe the operative statute for us to look at that's really dispositive is BCL 725F. And that's, I think, somewhat of a unique section. And the reason that's a unique section is in that section, the legislature actually goes out of its way to state that the indemnification provisions in that Article 7A apply to domestic and foreign corporations. Now, it's somewhat unique because, of course, we know that the BCL applies to corporations. So the legislature is going out of its way to suggest and to tell us that in BCL Article 7, with respect to indemnification, we only have to look at corporations, both domestic and foreign. And I submit the reason, Your Honors, that the legislature has done that is precisely to avoid the type of confusion we have in this case, where other similarly situated kind of entities or organizations may have similar board compositions, but the legislature is clear that these indemnification provisions do not apply to that particular type of setting or organization.
The RPL actually expressly provides that a condominium association can be incorporated, correct?
Yes, that's
now,
RPL.
when that occurs, when you do have an incorporation, does the BCL apply?
At that point, yes. At that point, once the incorporation occurs, and I believe the citation is RPL 339-1VA, the very first provision in that section of the RPL says that in fact, an unincorporated condominium could avail itself of the ability to incorporate. And once that happens, then the BCL would kick in at that point.
But generally,
in your scenario, if we accept it, they could provide for that right in the bylaws.
Your Honor, all cases are clear that the bylaws are always paramount. The bylaws are always paramount in both instances. And I would point to the Claremont Green case, which is cited by both sides. And in that case, Justice Demarest goes out of her way to suggest that even though the BCL is being used as a sort of guidepost in that case, it mirrored the image, the BCL mirrors the bylaws. The bylaws contained provisions that were being applied in Claremont Green in the BCL. So the wellspring of authority is always the bylaws, and that's true for both condominiums and co-ops, of course.
Now, counsel, this is Judge Singh. I think I read in one of the cases that generally condos are unincorporated associations. Is that correct? So are there benefits? Are there benefits to a condo other than obviously application of the BCL to stay in this unincorporated status? So is that a conscious decision that's made?
Oh, it's certainly a conscious decision, Your Honor. And I would point to what this court said actually in the first Pomerantz decision in 2013. And in the first Pomerantz decision in 2013, this court said specifically that condominiums and the unit owners in condominiums should have equal rights and equal standing to chart their own course as the tenants in a cooperative unit. And I think that's an important point to mention, because if we look at what's been applied in this case, that actually is not happening. In this case, respondents would have us believe that the condominium somehow has lesser rights than the co-op because it has to be, if you will, subservient to the BCL and under the auspices of the BCL, when that was not a conscious choice that was made. And again, it goes back to the bylaws, which in this case have been in place since 1983, which is a long time. So at any point during that time, this condominium could have chosen to do a number of things. It could have chosen to incorporate, or it could have chosen to amend its bylaws to include a specific provision for indemnification that respondents urged and the trial court seemed to believe it must apply. But of course, that hasn't happened. There's a very limited, specific indemnification provision in this case, which relates to third-party contractual liability. And I would just point out that even if we do apply the BCL, that BCL 725B2 still gives effect to those bylaw choices. So even if we were to apply them,
You're out of time, so I'm going to ask you, you can elaborate that you still have rebuttal. Okay.
Thank you, Your Honor.
All right, thank you. All right, respondent?
Good afternoon. May it please the court. Jason Zakai of Hiller PC for respondents cross appellants. Your Honors, this court holding in SWE and the other cases applying the BCL to condominiums do provide a basis for an affirmance. In this court applied the BCL 626E. It was not a incorporated condominium. Many of the other cases that have applied the BCL to condominiums were not incorporated either.
Counselor, this is Judge Singh. What about, we have a number of cases that expressly state that the BCL does not apply to an unincorporated corporation or condo association. What effect should we give to that language in those cases?
The cases are clear that have, the Pomeranz case said you look to guidance where the RPL is silent. And in that case, the RPL was not silent, so it was not applied, as the trial court distinguished that case. But many of the cases are consistent.
Well, is there a difference between guidance and binding effect?
There is a difference, but in the cases that have applied the BCL, Your Honor, they have applied substantive rights and obligations under the BCL.
Well, in SUI, we really didn't do that. It was one sentence with a seaside to the BCL. I don't think that was a blanket application of 626, and possibly, an oblique reference to guidance from the BCL. I know I wouldn't disagree with you if you told me BCL provides guidance.
The court in SUI only cited to the BCL and did not cite any other authority in holding that the attorney's fees can be applied.
But let me just interject. This is Judge Manzanet. The sentence specifically said plaintiffs may pursue their claims for attorney's fee to the extent it relates to the breach of contract and breach of fiduciary duty causes of action. There are no such actions remaining in this case. Am I correct?
Those actions were brought in this case.
But they were dismissed. So if they were dismissed, then our one sentence in SUI does not apply to your circumstance in your case.
It does apply because Ms. McGuire had to put out litigation costs and expenses in defending against those actions.
Yes, but our one sentence did only limited it to the breach of contract and breach of fiduciary duties claims.
Those were the facts in that case. There were several breach of fiduciary duty and breach of contract claims in this case, and the claims
that were dismissed, were they dismissed on the merits?
No, they were not dismissed on the merits. They were dismissed on procedural grounds.
Right. In other words, substantively, they should have been brought derivatively.
The trial court,
and that's what the court found, and that's a binding because that didn't get appealed.
There were two bases for the dismissal. One, they intermingled direct and derivative claims, and two, because the claims were derivative in nature, the court found that the appellants did not make a proper demand or show futility on the board. And by the way, we argued that they didn't comply with 626C, which makes that requirement. And the trial court applied case law that had relied on 626C. And
but we didn't review that. I mean, that's really the issue that's up here now. I don't know whether that was right or not, but okay. But actually, there's a lot more case law. I'll give you that embraces those concepts of derivative actions in the context of condominium associations. And I guess really what we have to decide is whether that's a strict application of the BCL that then means that the BCL applies in all contexts, or whether that's a different animal, right? I mean, that's the issue.
Your Honor, for the purposes of this case, we're just asking about BCL 722 and 724, not a blank
I know, but it's a slippery slope. If we start to do that, then where do we stop? Really? Well, where do we stop? Isn't it a legislative function where the legislature should come in and say, you know, we like those rules we have in the BCL, we're going to impose them on condominium associations?
Well, I would just add that given the case law that exists, there should be a balance. If plaintiffs have the right to recover attorney's fees under the BCL or have the obligations to comply with the BCL and bringing demand upon the board or showing futility, there must be a balance, and defendant board members must have the right to seek attorney's fees as well.
I'm not sure they would have been able to get attorney's fees under the derivative action BCL provision, because that's for a successful plaintiff. These plaintiffs weren't successful. She was successful in defending it, but I don't know that there's a reciprocal right under that, is there?
There is a reciprocal right. It both goes to reimbursement of attorney's fees, whether you're on the plaintiff side or the defendant director side.
And a derivative action, yeah.
According to the Tsui case, they had been successful. And I see my time is running short. I wanted to just mention the cross appeal quickly. The trial court made one narrow error in misapplying the standard under the BCL. This was a request for interim relief, and therefore the provision 724C of the BCL should apply. It's a lower standard. Ms. McGuire should only have to show that she raised an issue of fact or law in the litigation, which she has done. Instead, the trial court applied 722C, which is the higher standard of proving good faith. And because this case is still pending, the interim relief should be the provision for interim relief.
You wouldn't have been entitled. I know it's interim relief. I know it's pendente lite, but that was a little confusing to me too, because if you're right on the law, the only causes of action that this would really attach to really are the causes of action that were dismissed. What remains, the nuisance. You can't get legal fees on that under the indemnification provisions of the BCL, assuming they even applied.
Well,
so I didn't really understand that.
The plain reading of the statute is dependency of litigation, and that's what
Any litigation. Yeah.
That's the plain reading of the statute, Your Honor. But even if the higher standard of 722C were to apply, Ms. McGuire clearly showed that she acted in good faith. The evidence is overwhelming in the record, and it's not rebutted. And so this is a poster child for board member indemnification.
Well, look, Counselor, this is Judge Singh. I think that your adversary's best point, and it's obviously the first point they make in their brief, is that as a matter of statutory interpretation, the BCL applies to corporations, which is a very basic concept. And I don't really see a good response to that by you in your brief with respect to that issue. I mean, you cite our cases where we have been informed maybe by the BCL, but when we really don't address the issue, this case for the first time will address that issue, application of the BCL, and why under these circumstances, given that the legislature is clear that it applies to corporations, should we extend it to unincorporated condo associations?
Your Honor, the RPL says that it should be liberally construed, and that's how the courts have consistently applied it. But
the RPL also says that you don't have to incorporate. And if you don't have to incorporate, you can go to the bylaws, and the bylaws can deal with indemnification as they do in this case. Doesn't that make some sense that the members of an association amongst themselves decide what their bylaws are, when they'll provide indemnification, etc.?
Well,
Sorry.
Your Honor, the RPL, the cases that have applied the BCL to condominiums have met in most instances involving unincorporated condominium. So we're just asking that.
But you agree they don't analyze it. You agree that there's no analysis as to whether or not there should be that application. We've cited to it. We've been informed by it, but we don't really address the issue, correct?
Well,
In
some of the cases, it's without question. In one case, in the second department, plaintiffs in a condominium were allowed to bring a cause of action based on the BCL without question. It was not even an issue. It didn't come up in that case. So it's often taken for granted that the BCL applies where the RPL is silent. And we ask that the same apply here. Thank you.
Thank you. All right, rebuttal?
Your Honors, I would just like to make 2 or 3 quick points. First is the legislature has also once again done the work for us already in showing that when it wants the BCL to apply to condominiums, it says so. And it said so in 2018 when it amended BCL 727A to provide for certain disclosure obligations that apply to both condominiums organized under the real property law and co-op units. So the legislature certainly is well equipped to amend the statute as it deems fit, as it did. And the absence of the reference to condominiums in one section is amplified by its inclusion in the other section. So the legislature certainly means what it says in these particular sections, and they have to be certainly strictly applied. And in fact, the United States Supreme Court gave us that guidance in June when it decided the Bostock case, and that we are sort of unable to stray from the straightforward statutory commands and the statutory language. And that's certainly not what's happened in the other cases that have applied or looked towards the BCL for guidance in the condominium context. And they mainly come up with respect to derivative actions that are functions of the common law. In each case, certainly again the Carper case, the common law is the actual thrust of how it goes to apply these BCL provisions, which are codifications of the common law that apply both to condominiums and the co-op units. Just to go back to one other point, Your Honors, in terms of how this guidance applies, the Tower case, which we cite in our brief, is also, I believe, very helpful. And that discusses sort of a basket of other factors we look at when the BCL is brought to bear for condominiums. And one of the things that the Tower Court looked at is the past practices of the condominium. And in this case, once again, since 1983, this indemnification issue has not been on the table with respect to this particular condominium. And the bylaws are meant to assure predictability. And just to mention one other point about the consequences of applying the BCL to this condominium, and Your Honor, goes to the point about where do we stop. Let's say, for example, the RPL is found silent with respect to transfer rights. Well, at that point, do we apply BCL 629 to condominiums, which state that transfer liability of the shareholder transferring is not relieved if the corporation has assets that are underwater? We certainly wouldn't do that because that would create chaos and disarray in the functioning and the actual operation of the condominium. And that's precisely what we have here. If the BCL is applied and the indemnification provisions are applied to this case in a closely held condominium like we have here, it would fall under the saddle of the weight of litigation. Because I would mention that the plaintiffs or the counterclaim defendants in this case, my clients, are also being sued for their breaches of certain fiduciaries' duties while they're on the board. So they would then be entitled to indemnification, and the same indemnification that the respondents.
Stop. Yeah. We understand your argument. Anything further?
No, thank you, Your Honors. We rest on our briefs.
Okay. All right, Counselor, you have 2 minutes rebuttal.
Yeah, I just want to respond quickly, Your Honors. My adversary mentions BCL 727, a new provision. Yes, the legislature added a new provision, but it did not change any existing provision. And to reverse the decision here would require overturning existing case law, including in this court. And although
Counsel, you missed the point that Counsel was making with regard to 727. It's not that overturned any law. When the legislature wants to make clear what provisions of the BCL apply to both those and co-ops, it knows how to do that. It seems to me as a very strong argument. Why doesn't that affect your claim?
The cases that have applied the BCL to condominiums that made no mention of real property law or condominiums. And the legislature added a new provision. They didn't go back and change an existing provision to say, oh, now we want to add condominiums, but only for this provision. This is an entirely new provision, and that's why it's different. And as far as the slippery slope, again, we're just asking for application of 722 and 724 of the BCL. And with respect to the Prepare case, that one case applied common law, but the other cases have not looked to common law. And so it's simply an application of the business corporation law. In addition, I just want to stress that the evidence on the cross appeal of the good faith of Ms. McGuire, she did everything right. This is the poster child for board member indemnification. We want to encourage people to join boards and not be faced with frivolous lawsuits by angry unit owners. Well,
you know, on some level, in the organization, particularly a condominium as small as this, they could have provided for this eventuality. You know, it's part of the cooperative ownership. And all right, any further questions, colleagues?
I would just add that under 724 of the BCL, it says that even if an entity doesn't provide for indemnification.
No, I understand what it says, but if it doesn't apply, then you know, if it applies, then I understand what it says. Yeah.
Thank you, Your Honor.
Okay, thank you.
Thank you.
Okay, we have the next case is Spielman versus 170 Broadway.
Good afternoon, Your Honors. May it please the court. My name is Seth Weinberg with Morrow Lilling the party, and I represent the defendant appellant 170 Broadway, who is the owner of the building in this case. And I'd like to begin with the Supreme Court's rulings as to notice. What the Supreme Court held was because my client had a representative on site who should have seen the door, that constitutes notice of a defect that the door would swing into the sidewalk. And our position is the Court of Appeals addressed this in Moss and found that the fact that an owner's on site and sees a defect doesn't constitute notice, such as to defeat common law indemnity, which means it's not active negligence by definition. In this case, the fence and the door was controlled by our contractors. It was controlled by McGowan because it was their means of egress. It was their emergency exit. It was controlled by McGowan to the extent that the fence needed to comply with the site safety plan, that they agreed.
Counselor, this is Judge Singh. Correct me if I'm wrong. Doesn't your client have a non-delegable duty under the administrative code to maintain the sidewalk? And couldn't that be a basis to find that there's liability, and the issue of whether there's a pass-through or not is something that might require a trial?
Well, I guess at 2 points. I'll take the second point first, Your Honor, which is a finding of 7210 liability, as we just found out from the Court of Appeals in the He case, does not mean active negligence, which would be indemnity, and it's our position that we don't need a trial in this case for that issue. But it's our position that 7210 does not apply to this case because we're not dealing with a defect of the sidewalk flag itself. We're dealing with a transient condition that may interrupt the flow of traffic on the sidewalk, but it is not the equivalent of the shunting that was found in the Doyley case and the Cook case, because what those structures did, if you will, is they changed the condition of the sidewalk flag itself. And as we know from Bucciatova—
I'm sorry, counsel, this is Judge Manzanet. Isn't this situation worse in that with the shunting, at least one can say arguably that a pedestrian should see that as they're traversing a sidewalk, whereas here, someone is traversing a sidewalk and all of a sudden their face is slammed with a door. Those are two totally different scenarios, and I don't think they're comparable.
Well, again, Your Honor, I can only say that our position is that the Court of Appeals to date has limited this section to the sidewalk flag itself, and this court has not applied it to anything other than a structural change to the sidewalk flag.
Well, could there have been a special use here under the circumstances?
No, because special use cases, and every special use case that this court has found, has required some sort of structural change to the sidewalk or the street. So, for example, building a sidewalk shed that damages, or building a sidewalk shed that damages the sidewalk physically could be a special use. But in cases, for example, where businesses have lined up their customers on a road to get into a gas station, that's not a special use. And it's the same thing here. What the door did is,
I'm sorry, could you tell me whether the request to change the direction in which this door swung by your client, how that impacts this fact pattern, since one would presume that prior to making that request, you were aware that there was no, what do they call it, a setback for the door, so that if it opens out, it would not open out into pedestrian traffic?
well, I think in this case, Your Honor, we asked for a door that swung out, which I would add is a requirement because it's the emergency
That was
exit.
a change, though.
It was, but my
Okay,
point would
and
be-
so my point is, when you ask for that change, I would presume that a careful owner would look at the original plans and see that there is no setback, and so would either require that the change of the door swing would also include the change of the layout so that you would not put pedestrians in danger. Why should you, in light of that fact, be let out or be granted contractual indemnification or common law indemnification?
Well, for the reason that we were a thoughtful owner and that we required our contractors to abide by all codes and regulations, to file appropriate safety plans and do the work appropriately. I don't think at that point what the court would be saying is an owner who asks for a change needs to go out of its way to say, and it must comply with all of these provisions and all of these safety measures, as opposed to just saying, this is what I want. You're the contractor. You're the professionals. Do it in a safe manner.
Except owners have a non-delegable duty. How difficult is it to say, make sure that it comports with the laws of the city and state of New York?
Well, we did that by requiring in our contracts that all the work be done in accordance with the regulations in the state and the city of New York. So I think non-delegable duty means by definition, we're liable because we weren't negligent. So I don't know how having a non-delegable duty means somehow we could be negligent. They're two separate concepts.
I'm not sure I understood that last sentence, and I don't think I'm the only one confused.
So Counselor, in this case, my recollection is that there was a fine, correct?
There was.
And the fine was shared in part by your client as well, correct?
The fine was paid, yes, not directed to my client by the city, but paid.
Well, but
yes.
was paid in part or whole by your client. Is that something that we could take into account as to whether or not there's some issue of control over the door?
No, that's a business decision that we made. The only entity that was required under the contract and under the rules of the city of New York to make sure that that door complied with the site safety plan was McGowan. That's why McGowan got the fine, or McGowan was the one that was sanctioned and given violation and the stop work order.
Yeah, you paid the fine in part.
In part.
You say for business reasons, but doesn't that just raise an issue of fact for a fact finder to really determine how liability, if any, should be apportioned between the two GCs, McGowan and Colgate, and yourself?
I don't believe so, Your Honor, because again, now what that would be doing is saying that we controlled construction of a door and that happened in the past.
No, it's not saying that. It's saying there's an issue of fact. That's a tribal issue of fact as to whether or not you had sufficient control so as to impose liability, right?
Well, if that's the case, then there still needs to be reversal because the Supreme Court found I'm negligent as a matter of law and I had notice of this door and had control. So if Your Honor wants to use that as a basis for questions of fact, then I ought not be negligent. I'm the only one so far that's been found negligent as a matter of law.
Well, because you have a non-delegable duty. You have a non-delegable duty, and the question is whether is it a straight pass-through or not, or whether there was active negligence, right?
Well, correct. So
deciding that issue, that issue is still on the table.
No, it's not, Your Honor, because the court found I'm negligent as a matter of law, and there is no circumstance in this case where I can get a complete pass-through as the order stands today. The order gives me partial contractual indemnity against only Colgate and McGowan. So to the extent Your Honor is suggesting there need to be questions of fact as to whether I get an entitled pass-through or an entire pass-through or a partial pass-through, that would require a reversal or modification, depending on how the court phrases it, to send it back. But as of today, I don't even have that right. As of today, it's been found, not only do I have a non-delegable duty, but I was actively negligent such that I can never get a pass-through. And that there's a question of fact as to whether I can get any indemnity from DiMartino, even though it was DiMartino's responsibility to make sure this wall was built appropriately and subcontracted the work out to Colgate.
All right, Counselor, right, finish up because your time is up.
Your Honor, if the court has no other questions, I'll save the rest of my time for rebuttal.
Okay.
Thank
Any
you.
other questions by my colleagues? All right, Colgate, you're up next.
Good afternoon. Thank you. May it please the court, my name is Yolanda Ayala and I represent the respondent cross appellant Colgate Enterprises. Colgate appeals the award of summary judgment to the plaintiff against Colgate upon the basis that the lower court improperly found that Colgate must have installed the single outswinging door that caused the plaintiff's accident. In doing so, the court completely ignored the fact that Colgate did not attend the meeting where it was discussed that a new set of metal doors and a single door would be installed. Also, Colgate had no involvement in the ordering of the doors, and there are absolutely no records indicating that Colgate was paid to install a new single green wooden door. In contrast,
So I'm sorry. What's the issue of fact? Is the issue of fact that there's a dispute as to whether it was a plywood green door, as plaintiff testified, or whether it was a metal door? Is that what you're saying is a genuine issue of fact?
Yeah, the lower court said the plaintiff was struck by a door installed by Colgate. There's no evidence that a single wood door was installed by Colgate. The only evidence is that Colgate installed a double metal door. So it's our position that the court improperly found that we installed the door.
Can I ask a question? Is there an issue as to whether this plaintiff was indeed struck by a door and was knocked unconscious on the ground on the side of this building? Is there any issue of fact as to that?
No, there's no.
Okay, so really the issue of whether it is a green plywood door or a metal door is an issue of fact and not really the crux of the appeal here.
Well,
correct?
Not necessarily, Your Honor, because the lower court found that issue immaterial, and we believe that
only speaking for myself, as do I. The man was knocked unconscious, so what he remembers is, subject to.
Your Honor, he was not knocked unconscious immediately. He was struck. He fell to the ground. He was asked 8 times in his deposition to describe the door, and each time he said he was certain it was a single wooden door. His wife, who came to this, spoke to him shortly after, confirmed. He said it was a wooden door.
I understand.
Can I ask you a question? I mean, because this was kind of quite, I just swirling through my head. Was there any other door on this site?
Well, there's one single door, and then there's this double set of doors.
And the one single door is, what material is it made of?
According to the plaintiff, it's a
no,
wooden
not
door.
According to the plaintiff. Is there any question that is there a wooden door and a set of metal doors, or are they all metal doors?
There's from the record, there's certainly the double set was metal.
And what about the single door?
Some people weren't sure what the door was, but.
Well, what did your client think it was? Your client was on site. Your client knew the grounds. And what involvement did your client have with any single door on the premises? What involvement, if any, did your client have with the single door, regardless of what the material was?
None. The only written documentation in the record indicates DiMartino ordered a double metal door and a single door. And the same records indicate Colgate installed a double metal door, but there's no indication at all that Colgate installed the single door. And that's why that issue is pivotal in terms of Colgate. Because
and I'm sorry, the single door, was that wood or was it metal? I mean, what does the record show?
it's not clear in the record, you know, other than the plaintiff's testimony, repeated testimony, that it was a wood door. You know, the logs don't specify, they specified the metal, the double doors were metal. It doesn't specify the composition of the single door. So it's our position, at minimum, there should have been an issue of fact resulting in the denial of the plaintiff's motion for summary judgment, as well as 170 Broadway's motion for contractual indemnification.
Question, in the record, is there any evidence that anyone other than your client was the party responsible for installing doors?
Well, no one knew. The testimony was DiMartino thought that Colgate may have done it. McGowan wasn't sure. Nobody was sure. And there's no records. There's no payment records that Colgate installed a single door. There's no evidence of who installed what other than that metal double set of doors.
But people have various responsibilities on a construction site. Your obligations,
right, but there was nothing.
There can be uncertainty about who put in the door.
There was nothing precluding McGowan for doing it directly, DiMartino doing it directly. There was another contractor, ABC, that's noted as putting in the hardware for the double doors. They may have done it. There's a host of several contractors that could have installed the single door other than Colgate. There's simply nothing in the record to confirm that Colgate installed anything other than the double set of metal doors.
Thank you, Counselor. All right. The attorney from McGowan. McGowan? Are you muted? McGowan?
Right. Counsel, your mic is muted.
I apologize.
You're still muted.
Here we go. May it please the court. Judge Manzanet, I just want to respond to something you asked Ms. Ayala that she could not respond to. There is absolutely a question as to whether or not the plaintiff was conscious after this fall. He testified at length about sitting on the ground, seeing this door for 20 minutes. That's his testimony. There is no evidence in the record whatsoever other than anecdotal evidence from the plaintiff saying, I was unconscious. There's no medical evidence to that effect because there is no medical evidence that he was unconscious. There was nobody who saw him and recorded him being unconscious at the accident site. So yes, it is a very important point, whether it's a green door or a blue door or a metal door. But as to my portion of the appeal, what 170 is asking you to do where it concerns McGowan is they're asking you to find common law and contractual indemnification over a party who has no responsibility for the scope of work. Initially, McGowan was responsible for an entire job site. About 4 months before this accident, the ownership entity hired a different contractor, DiMartino, to be responsible for the first 2 floors. As part of their responsibility, they had to move existing doors and fences. It was clear to everyone, it is admitted by DiMartino, it is admitted by 170 Broadway, the owners, and by McGowan, that McGowan had no responsibility over the operations of DiMartino. In fact, 170 Broadway never even held coordinating meetings between the two of them. So if there was an issue with something from 170 that McGowan had an issue with this door, the only thing they could do was tell the ownership who had to take care of it. So sitting here and saying that Moss applies because just knowing isn't enough, the 2 affidavits by Mr. Atherson, which are in the record, one of them is at page approximately 2284 and the other's approximately 1826. those two records, he says he knew about it and he told them to make changes because it did not apply to the DOB requirements. As the drafter of that site safety, all I could do was say, hey, look, this site safety is no longer being followed by your other contractor. And at the time when this accident happened, there were violations issued. McGowan, from the moment of issuance, disputed those violations as being within its scope of work. But at the request of ownership, and with the ownership's permission and additional payment to McGowan, 4 parties paid off these violations with no adjudication to get the stop work order closed and get the project reopened.
Well, Councilor,
And these violations are the sole reason.
Councilor, this
Yes.
is Judge Singh. Couldn't the violation itself and the manner in which it was disposed of by the 4 parties raise some kind of question of fact as to who had control over the door at trial, and that we should allow that decision to be made at trial as opposed to making that determination on this record?
I absolutely agree with you. And that's why I believe that the granting of contractual indemnification solely based on quote unquote violations that were inappropriately given to McGowan should not form the basis of contractual indemnification. You are absolutely correct. It's a huge, at bare minimum, it's a question of fact as to who was responsible for that work.
All right,
And McGowan's
I'm gonna
position has always been.
Councilor, wrap up your argument because your time's just run out.
Okay, the only other thing that I'll say is that as to the dismissal of the affirmative defenses by the plaintiff didn't even make a prima facie case of entitlement on that, and it doesn't matter how big or good or bad the opposition was because the plaintiff didn't prove that they were not negligent, which they'd have to do for granting summary judgment.
I'm sorry, what duty does the plaintiff have who's walking on the sidewalk and a door opens up, hits him in the face, and he's on the ground? What duty does the plaintiff have with respect to
He minimally has to take care for his own safety.
So he knew a door was going to open up in his face on a sidewalk?
He's walking along a construction site under a sidewalk shed. He admits he wasn't paying attention to where he was going. He wasn't looking. He didn't take care for himself.
Even if he was looking, how is it causally related? The doors came out of nowhere.
That's his version of the accident, yes.
And you have no contrary version.
Nobody else knows how this accident happened. All we know is he was certainly close enough that a 6-foot door hit him in the face. Or so he claims. Nobody saw the accident, it's unwitnessed.
But it's not like he fell into a hole that he should have seen. A door just came out of nowhere and hit him. I don't understand how he can be responsible for that.
He can be responsible for knowing that he's next to a construction site, walking along a fence that runs from one end of the road. This is a very large construction site.
So you're saying every New Yorker has to now walk as far away from a building that is under construction because it's our duty to anticipate that some door in a construction site is going to swing open and slap you in the face. That's what you're saying.
I'm saying you should be walking far enough away from the construction, from the fence itself.
But isn't that the purpose of why the doors had to be recessed? He's supposed to believe that you're going to violate the law, or whoever violated the law, and that this door is going to swing out to the sidewalk. I have trouble with that.
And isn't that also
doesn't make any sense?
Isn't that also the purpose of the fence, that's supposed to protect passersby from the dangers at the construction site? So you're supposed to assume that the fence is in the wrong place and it really you have to take care for another 4 feet on the other side of the fence? That makes no sense.
I think a person has an obligation to watch their surroundings.
Okay, we understand your argument. Any further questions, counselors? I mean, colleagues? All right, Attorney for DiMartino, you have 3 minutes.
I'm Mary Ellen O'Brien. I'm here on behalf of Respondent DiMartino. I am basically addressing the contractual and common law indemnification questions raised by 170 Broadway. It is DiMartino's position that there has been no showing that from a prima facie point of view, that this has arisen out of their work, which is the specific language and the contractual.
Counsel, but under your contract with 170 Broadway, you're responsible for construction means, methods, technique, sequence, and procedures of all of the retail project work, right? Which is on the first floor.
Correct.
Okay, and so I would presume that this fence is considered part of the first floor?
Correct.
And are under your contract, aren't you also required to indemnify for the work of yourself and the subcontractors?
Yes.
Okay,
but the issue here, Judge, if I may interrupt, is that we completed that work. We basically constructed the fence. Our design plan, which was submitted by Mike Eggers, a person recommended to us by 170 Broadway, had the doors all opening inward, which was done. A dispute then arises as to whether or not one of the doors has to be opening outward as an emergency door that would lock after it was closed. A resolution was reached, and that resolution was directed by 170 Broadway's Pete Atheson and Kevin Clancy, I believe, was the other gentleman. And that the resolution was that we would order hardware for another contractor, whether it's McGowan or somebody they hired, whether it's Colgate, to then go and change or modify the work we had done. And that is,
again, aren't you responsible to indemnify for subcontractors? And if so, even if one of these other subcontractors did the actual work, how does that relieve your client?
well, one of those subcontractors was McGowan, who is actually the GC. It's not just a subcontractor. The subcontractor is Colgate. We don't know. Colgate admits to or concedes that it modified a door. Whether or not it's the single door or double door that hit him remains a question. But the bottom line is that we were not in control of that subcontractor before that change.
Counsel, is there a concession by McGowan somewhere in the record, perhaps I missed it, that they actually did this work since their contract made them only responsible for providing and implementing a site safety plan?
Well, their contract makes them responsible for the site safety plan. That is correct.
That's
we were not the contractor responsible for the site safety plan. We did a design plan for this.
Counsel, please listen to my question. Was there any evidence in the record? And if there was, please, I missed it. So tell me where it is that McGowan at all says that they actually did any work in replacing a door. Any door.
The question of fact is testimonial. Our Miss DiMartino principal says it was, he doesn't know, he thinks it was McGowan who hired Colgate, or it may have been another subcontractor, because they were the ones directed by 170 to change or modify our work. That is the testimonial record. Is there any other evidence other than what the contractual duties are? No.
Okay.
Okay. Colleagues, any further questions? All right, we have rebuttal for 170.
You're muted.
You're on mute, sir.
My apologies, Your Honor. I've been muted so long I forgot.
It's an interesting observation.
Councilor McGowan, sorry, Your Honor. Councilor McGowan asked the rhetorical question, what else were they supposed to do? How were they supposed to make this safe? And I think the answer comes from the site safety supervisor they hired who testified, I walk around the fence every day. I'm responsible for making sure the fence is safe and everything else. And he's asked the question, if there was no delivery being made, would the flagman be in use? This is at page 1071 at the record. Answer, the site safety plan shows the flagman at all times. So they should have complied with their site safety plan, put a flagman at the door. And then you'd have stopping of traffic when the door opens. That's what they could do. That's a further showing of their control over this door. With regard to Colgate's point, it didn't install the door. I just want to briefly go through the history of the job very quickly because I think it explains the issue. Originally, the entire project was McGowan's, and they built a sidewalk shed, and they hired Colgate to do it. The work was delayed. The job was split in two. The upper levels stayed with McGowan. The lower levels went to DiMartino. DiMartino needed the sidewalk shed moved with doors and all. And Colgate did that work as a subcontractor for DiMartino. So the evidence is, regardless of whether it was a wood door, metal door, etc., that all the doors that anyone knows about were installed by DiMartino. I'm sorry, by Colgate. So the idea that which door, I don't know how that's relevant to Colgate, but to my client, if it's the wooden plywood door, we didn't ask that anything be done with that. So this notion then that we somehow controlled the work on the wooden door and are therefore negligent goes away because we asked for the other metal door to be recessed. We had no
Is there a wooden door on the project?
It's unclear. There is testimony there were two doors on Maiden Lane. I'm presuming they were all wooden doors when the wall was originally installed. It was all wood.
This is just fascinating to me that this would be a fact that, you know, it has an objective reality. I don't know what's going on here, you know?
Everyone but plaintiff was under the impression he was hit by the metal doors. Everybody but plaintiff. That's all I can say. So both doors were installed by Colgate. That's the only evidence out there because they installed the whole wood wall, doors and all.
But I don't really understand how that creates a question of fact. He's not in the construction industry. He was just walking along and got hit. So I don't understand why there isn't a stipulation as to what the door is made of that hit him. I can't even. Well, it just seems to me that this is dancing around a question which nobody should be wasting time on. It seems very strange to me that it's sort of lawyers are making a lot of an issue that can't possibly be an issue in real life.
My only point with regard to the wood door is if it is the wood door, there's no dispute my client had anything to do with a wood door, asking that anything be changed on the wood door. Plaintiff in his brief says it's the metal door now. Plaintiff below says it's the metal door. So I'm not suggesting there is or isn't a question of fact. I'm merely saying if the court finds there is one, then that inures to my client's benefit to the extent it's been found I was negligent for having some level of control over this metal door. That now we're going to talk about a question of fact.
But Counselor, I'm not sure I agree with you. I'm not sure I agree with you with that premise because the theory against your client is a non-delegable duty with respect to the sidewalk. So it doesn't really matter whether it's a wood door or a metal door. You're responsible for for the protection of pedestrians traversing on that sidewalk. So why does it matter whether it's metal or wood?
Well, here is why. Because I can have a non-delegable duty, not be actively negligent, and still get indemnity.
And that is an issue of fact. I will probably concede that, at least speaking for myself.
So that's my point. My point is right now the court has found I was actively negligent. And if we're going to find questions of fact about the door and who said what, then it cannot be that I was actively negligent. I would submit I'm not 7-10 liable either, but even if I am, that finding in and of itself can't be I'm actively negligent. That alone means I have a non-delegable duty and therefore am entitled to a pass-through from my contractor who was required to make sure the doors followed the site safety plan and have a flagman, my contractor who was responsible for the first and second floor to build the wall, and the subcontractor hired by both of my contractors to do the work. And at that point, we're not talking about apportionment and partial indemnity. To me, we're talking about apportionment amongst the other three entities, and I'm along for the ride as a non-delegable duty But at the end of the day, it's not really my case. It's my contractor's case, and they would owe me indemnity. So that's why I keep harping on non-delegable versus active. So if the court has no other questions, I'll rest on my briefs.
Any other questions, colleagues? Thank you. All right, Colgate, your rebuttal?
Yes, thank you, Your Honor. On 1734 of the record, the DiMartino logs clearly state that DiMartino ordered a set of metal double doors and a single door. So what counsel just said that, oh, Colgate must have installed or moved the doors because they did the original fence installation is not borne out by the record. The record clearly shows whole new sets of doors were ordered and installed. Who installed that single door is unknown. There's not a shred of paper evidence indicating who installed that door. To say it was Colgate.
Well, the doors that your client installed, were those the ones that should have been but were not recessed?
Yes, they were out swinging. They were not recessed because we were following DiMartino's design plan, which did not require that it be recessed. The other point I would make is, unlike the other defendants, we were not aware of the stop order. We didn't attend the meeting after the accident. We were not assessed to share in the fines from the violations. We weren't even on the site for a month before the plaintiff's accident occurred. And lastly, 170's reliance on the Moss case is completely distinguishable. In Moss, there was a complete shifting from the owner to the contractor. They were on site 24 hours a day, 7 days a week. They had regular inspection duties and they had regular maintenance duties. Here, Colgate did their work, installed, and were off site unless they were called back. Completely different scenario. Thank you.
Thank you. All right, finally, we have rebuttal from McGowan. Go ahead.
As to the flagman, first of all, the flagman should not even be an issue in the case. It was any claim that the flagman had anything to do with this case was withdrawn on the record by the plaintiff during oral argument. It's also reflected in the judge's decision. I think the decision that's at page 13, the withdrawal by the plaintiff is at page 58. As to, even if it was a portion, 170 Broadway totally took Mr. Nowak, the site safety manager's testimony, out of context. The rest of the sentence is, but you really only need a flagman if there's deliveries going across the sidewalk to protect the pedestrians at that point. You don't ever need a flagman in front of a construction site 24/7. And that's also reiterated by Stephanie Colblay on behalf of McGowan when she was asked the exact same question. When do you need and why do you need? There's no expert testimony that refutes that. So the only two people who talk about flagmen, which, like I said, has nothing to do with this case, say it's only necessary for delivery purposes, and that's not the case here. And the other distinguishing feature in Moss is that Moss was after a liability verdict had been taken place. There was a jury verdict in Moss, and they found that the contractor was responsible. There hasn't been any findings here that anyone is responsible. McGowan cannot be held responsible for the work of a totally different, not subcontractor, general contractor. There's two separate general contracts here. One is with DiMartino, and I will admit, Mr. DiMartino blamed everything, and I do mean everything, including the color of the grass, on McGowan. It was so bad during the course of that deposition, I actually had to stop him. I said, look, I get it. You're blaming my client, but let's answer some questions. So I understand exactly what Ms. O'Brien is saying. But the reality of this is it would be patently unfair, not just in this case, but in any case, to hold one general contractor responsible for the scope of work of another when there aren't even coordination meetings. And the responsibility for that coordination and the interaction between the two people is the ownership. 170 Broadway kept that responsibility for themselves, by not having any interactions between DiMartino and McGowan. That's their actual negligence, and that's why they're not entitled to indemnification, common law, or contractual from anybody.
All right. Thank you, Counselor. Any further questions? Thank you all. We concluded.
Thank you.
Okay, the next argument, ABB Inc. against Monaco Ceiling Solutions. Step up.
Good afternoon. May it please the court. Andrew F. Bain from McElroy, Deutsch, Mulvaney and Carpenter for defendant appellant.
Yeah, I miscalled that, but the right people stepped up, right? Haley
Yes, Judge.
against ABB. Okay, go ahead.
And like I said at the calendar call, I'm accompanied by Stephanie Eaton, a member of the North Carolina bar, who was admitted pro hoc vice, and I'm respectfully requesting that she be allowed to argue.
I'll allow her.
Thank you.
Thank you, Your Honors. May it please the court, my name is Stephanie Eaton. I'm at the law firm of Spillman, Thomas & Battle, and I'm here on behalf of the appellant, Monaco Ceiling Solutions Incorporated, a South Carolina corporation. And throughout this argument, I'm going to refer to them as Ceiling Solutions. This is an appeal from an asbestos case where the plaintiff sued the wrong company. We know that because in January of 1995, there was a contract entered between Monaco, New York, Monaco Packing and Rubber Company, Inc., a New York corporation from Can you hear me?
This is Justice Gasmer. How do you avoid the effect of collateral estoppel in this case where there are two prior decisions affecting your client? I just don't understand why this one should be different.
Sure, and that's a good question. Under the case of Schwartz versus Public Administrator County of Bronx, there had to have been a full and fair opportunity to litigate the issue of personal jurisdiction and successor liability, and there hasn't been. And how do we get there? First, if you look at the Herlihy order, which is in the court's record at 1124 to 1131, and look at what was before the court in that case. At that time the Herlihy order was entered, the order itself was based upon evidence in the record, which was a testimony by Mr. Denton Taylor taken September 22nd, 2011, a deposition of Ms. Walsh taken April 11th of 2012, and the deposition of the current owner of Ceiling Solutions, Mr. Wachter, on April 11 to 12, 2012. And based upon the deposition testimony, the court concluded that, quote, this is evidence that Monaco, New York was not, as defendant urges, sold to Mr. Taylor, but rather that Mr. Cullen simply continued his operation in South Carolina. But there was some key evidence that the court in Herlihy did not have. Namely,
what was that?
I'm sorry, I couldn't hear your question.
Go ahead.
Finish. Go ahead. Judge Gesmer, you finish your line.
Appeal from that decision?
Excuse me?
Did you appeal from that decision?
The Herlihy order, the trial court was appealed. And then there was another decision, ultimately when the contract was discovered in 2018.
When was that contract entered into?
It was entered into in January of 1995.
So that was before the Herlihy decision, correct?
Correct.
So here's my question to you. When it comes to collateral estoppel, the party who says, gee, I didn't get a chance to put in the contract, but they could have put in the contract. After all, it was your client's contract. They had it. Why should we now say you get a redo on the issue? Isn't that the whole purpose of collateral estoppel?
No, because A, it wasn't our client's contract. Our client is a South Carolina corporation that did not exist until after the contract was entered.
Well, that's a little glib because we're talking about successor jurisdiction. So who was the contract between, and who had that contract in their hands? Wasn't it the new principal of the corporation in South Carolina? Didn't he have that contract in his hands?
Your first question was about who was the contract between, and the contract was entered between Monaco Packing and Rubber Company, Inc., a New York company that existed between 1958 and
wait a minute, wait, because I feel like this is a little sophistry. Who is the principal of Monaco, New York?
At the time of the sale, the principal's name was Dennis Cullen.
And who's the principal of South Carolina Corp?
Her name is Brenda DeWachter.
And when did Mr. DeWachter become the principal of South Carolina?
She became the principal of Sealing Solutions in, I think it was 2004 when Mr. Cullen passed away.
So in 1995, Mr. Cullen was the principal.
Excuse me?
In 1995, when the contract was entered into, wasn't Mr. Cullen the principal of the South Carolina company?
No, because the South Carolina company didn't exist yet. Wasn't formed yet.
Again, aren't you being a little glib? And I don't use that often, but that's the whole issue. Was it the same person who was the principal of one company who became the principal of the new company? In other words, this isn't a contract that just came out of the blue. For goodness sakes, the principal of South Carolina knew about this contract. Had to.
He may have known about the contract. The issue, though, is when decades later, asbestos litigation is filed against the South Carolina company that never manufactured or sold anything asbestos containing and didn't even exist at the time of the contract. By that point in time, for example, Mr. Hurley's case in 2011, Mr. Cullen had been deceased since 2004. Mr. Wachter had the corporate records of her South Carolina company, but this contract had nothing to do with the South Carolina company. It was a contract for the sale between a New York company, Monaco Packing and Rubber Company, to another New York company, Denton Taylor Industries.
But the New York company that made this was
had discovery. You had the access to discovery. Couldn't you have gotten that contract?
I mean, the contract was found in Mr. Cullen's estate file. It had nothing to do with the South Carolina company. It had nothing to do with discovery. It was inadvertently found. And as soon as it was found in 2018, we produced it in discovery in the Hurley case, provided it to the plaintiff's counsel so that they had an opportunity.
You provided it in the Hurley case.
Correct. We did in the discovery. It was the first document that had ever even been produced because our client had no records from the New York company. The New York company records would have, if any, have been retained by Denton Taylor Industries, who, as we show in the record and pursuant to the contract, which is at record pages 85 to 91, Denton Taylor Industries continued doing business as Monaco Packing and Rubber Company, Inc. in New York City. Denton Taylor Industries did business, literally doing business as Monaco Packing and Rubber Company, Inc. out of the same leased premises that he took over from Monaco Packing and Rubber Company. Denton Taylor Industries sold.
That was all considered by Judge Heitler. And I guess the contract, you produced it in the Hurley case. Somebody could have put it in front of the court. I'm not sure that contract, I mean, I looked at the contract here. I'm not sure it makes a difference anyway.
Yeah,
but
that's my question. What Judge Gish is getting at is, is, let's assume that the contract's newly discovered evidence. Why should you be able to get around collateral estoppel? Does that really show a sale of the company? Isn't it really just, it just shows that there was a conveyance of a portion of the assets?
No, that's not correct. You know, you've got to look at the contract as a whole, and the contract as a whole, it's called Contract for the Sale of a Business. That's the name of it.
Well, that's what it's called.
Mr.
What does it actually contain?
Yeah, it was the sale of the business because Mr. Taylor.
Didn't 6 out of 7 of the employees of the original company transfer and move to South Carolina to join the new company in South Carolina?
It's not a transfer, but yes.
My question, did counsel
move
counsel
to South Carolina.
Counsel, I asked you a question.
And you asked me
did 6 out of 7 of the employees from the original company relocate to South Carolina in order to join the new company in the same name, South Carolina?
6 of the 8 employees that had been working in New York moved to Greenville, South Carolina, and Mr. Cullen started a new company in South Carolina in February of 1995, and that new company worked with Mr. Cullen's client, General Electric.
Is it generally the practice of companies to take the accounts receivables, the pension plans from New York, moving them to South Carolina when they're forming a new company?
I don't know what would be
But doesn't that suggest, you may not know, doesn't that suggest, in fact, that it's just a continuation? It's a move of a company from New York to South Carolina, presumably for tax reasons or union reasons, and that's all that occurred here. The employees moved, the equipment moved, the accounts moved, the pension plans moved. That's what Judge Heitler found in effect, and that's what we affirmed, correct?
Well, that's what Judge Heitler found, because that was the yes. But that was based upon the evidence that was before the court in 2013, and that is not the evidence now. First, it's improper for the court to accept parole evidence about what a contract said from the witnesses in 2011 and 12, based on a 1995 contract that nobody had in their possession at the time. Nobody saw it.
Well, maybe those would have been good arguments to make in front of her at the time, but when we're applying collateral estoppel, we don't go back and say, well, all the arguments that you could have made and you didn't make, you can raise them again. You can't do that in any event. You're way over your time, so I'm just going to ask my colleagues if they have any further questions for you.
No, thank you.
Okay, and we'll hear from your adversary. You have to unmute yourself.
I just noticed that. Thank you, Your Honor.
Okay.
May it please the court. My name is Andrew Grouse of Walens, Goldman & Spitzer, and I represent plaintiff respondent in this matter. Defendant appellant is requesting for the 4th time a ruling that is not responsible for the tortious conduct of its corporate predecessor. 3 courts, including this one, have denied the same request.
Has the law changed since the time of the decisions upon which you want to claim collateral estoppel?
It has not, Your Honor.
Haven't we had changes in the law on jurisdiction?
Yes, but Justice Heitler, in her decision in Hurley, went through the personal jurisdiction analysis and found that defendant appellant inherited the jurisdictional status of its corporate predecessor.
Right, I know she did that, right.
And the 2 cases that are relied upon by defendant appellant in this matter do not change the law and do not represent a change in the law. Specifically, the 2 cases that defendant appellant relies upon in this matter are BRG versus Chevron USA and US Bank National Association versus Bank of America, NA. Just as an initial matter, defendants' appellant's argument that the Hurley court's finding of personal jurisdiction was based solely on a finding of successor liability is inaccurate and false. Rather, the Hurley court determined that defendant appellant was successor in interest to Monaco, New York, and that it inherited the jurisdictional status of its predecessor because, quote, the facts herein strongly suggest that Monaco, South Carolina was a mere continuation of Monaco, New York. Justice Heitler's analysis in Hurley clearly shows that she relied on the Seminets versus Sherling and Walding Incorporated decision out of the Third Department, which was affirmed by the Court of Appeals. And the Seminets decision states that a successor may inherit its predecessor's jurisdictional status if it is shown that there was a de facto merger or a consolidation of two entities, or if the successor is a mere continuation of its predecessor. BRG and U.S. Bank do not limit the applicability of inherited jurisdictional status to situations only involving a statutory merger, as defendant appellant suggests. First, neither BRG nor U.S. Bank were decided by either the First Department or the Court of Appeals. Second, both BRG and U.S. Bank rely on Seminets and recognize the inherited jurisdictional status exception. And third, a plain reading of both of these cases does not support defendant appellant's argument that the inherited jurisdictional status only applies to statutory mergers. Specifically, the facts in BRG demonstrate that the plaintiff failed to assert a claim that defendant inherited the jurisdictional status of its predecessor as recognized in Seminets. In U.S. Bank, defendant appellant places great weight on the fact that the Second Circuit cites Shannon versus Micro Copper Corp at page 157. However, the Second Circuit clearly states that Shannon is, quote, among the cases cited by Seminets where, end quote, where inherited jurisdiction status applies. By citing Shannon, the Second Circuit was merely highlighting one of the examples of where inherited jurisdiction status applies, and in no way rejected the other exceptions to the rule which were relied upon by Justice Heitler in Hurley.
Counsel, can you address the contract? Does the contract change the analysis, the contract that is either newly discovered or not newly discovered with respect to successor liability and really specifically on the issue of collateral estoppel?
Sure, and I want to direct the court's attention to the DeRosiers matter. This is, the DeRosiers matter was the second time that defendant appellant attempted to evade liability for its corporate predecessor. And I believe counsel misspoke, but the contract was actually produced in the DeRosiers matter, and that's when defendant appellant argued that it did not have responsibility. Now, with regards to the contract, Justice Mendez evaluated the contract and actually looked at the language of the contract, and he concluded that the contract itself does not demonstrate that Denton Taylor Industries is the true successor in interest to Monaco Packing and Rubber Company Incorporated. Rather, the contract simply reflects an agreement to sell Denton Taylor Industries the right to use the Monaco name and lease certain specified assets, and that's Justice Mendez's decision in the DeRosiers case at record 1137. Also, Justice Mendez found in that same opinion that, in the DeRosiers opinion, that the record for the instant case fails to present anything that would change the analysis of personal jurisdiction and successor liability already contained in Hurley v. AF Supply. Now, pursuant to Schwartz and Schwartz versus Public Administrator of County of Bronx, there are two prongs, two requirements for the invocation of collateral estoppel. First, there must be an issue which has necessarily been decided in the prior action and is decisive in the present action. And two, there must have been a full and fair opportunity to litigate the issue. Justice Mendez, in his decision in the Haley matter, he found that both of these prongs were met. Now, despite its multiple bites at the apple, defendant appellant, again, still argues that it did not have a full and fair opportunity to litigate the issue of the contract because it chose to settle the DeRozier's matter instead of appealing Justice Mendez's decision in the DeRozier's case. Defendant appellant cites Johnson v. Watkins for support. However, the facts in the incident matter are easily distinguishable, and that case should not apply. Specifically, the decision in Johnson hinged on the availability of an appellate review as opposed to one's affirmative choice not to pursue it. A complete reading of the Johnson decision demonstrates that its application should only be limited to situations where review is unavailable because the party who lost on the issue obtained a judgment in its favor. In the instant matter, defendant appellant completely exhausted its appellate review process in the Herlihy matter when it appealed Justice Heitler's trial court decision to this court, and this court denied leave to appeal to the Court of Appeals, and it had the opportunity to appeal Justice Mendez's denial of its motion to dismiss in the DeRozier's matter, but it simply chose not to. And Your Honors, that is my argument. I see the rest of my time and I rest on my brief. Thank you.
Any further questions by my colleagues? Okay, we'll have rebuttal.
Certainly. I can explain why Sealing Solutions was not given a full and fair opportunity to fully litigate the issue. And again, it stems from the Haley Court opinion below at record 4 to 10. When you read that, the court, quote, says, this court adopts the findings in Herlihy and DeRozier's that Monaco Sealing Solutions, Inc. is the successor to Monaco, New York.
Excuse me, counsel, why weren't you given, in what way were you deprived of a full and fair opportunity to litigate in DeRozier where you had the contract?
Certainly, I can explain that. And we have explained the background of the DeRozier's case in the record at pages 8 to 9. What happened was after we lost the order, the motion was denied. We filed a motion for rehearing, and we filed a notice of appeal. However, the case was called for trial before we could get the appeal heard by this department. And that was significant because obviously our client is arguing it's not subject to the jurisdiction in the first place.
Did you try and seek a stay?
Well, we had a motion for stay, a motion for rehearing, and the notice of
stay on appeal. Did you come to this court for a stay pending of the trial pending the appeal?
I don't believe we did that because the motion to rehear was going to be heard about a week or so into the trial. Judge Mendez was not there for the pretrial conference, and we were there with Judge Schulman, and he said, well, you know,
he had no stay. He was going to go forward. So here's the thing, though. But if you had lost a trial, you could have still brought everything up for review, though, correct? Well, I mean, assuming that you wouldn't have gotten a stay, and it's not entirely clear to me that you wouldn't have on a jurisdictional issue that's brought up on appeal.
Sure. I mean, we looked at that, but I believe we were told at the time, or under the impression at the time, that we couldn't get a stay. So that forces our client.
I don't know why you would be under that impression. That is something that we consider on a routine basis.
But you made a litigation choice, counsel, and you're bound by that, and so are we.
And what was that?
You could have still appealed the issue if you lost a trial. There's no question about that.
Sure, but I mean the case law that we cited in our brief, and Johnson is just it's not limited to simply an involuntary appellate issue, and there are cases like Church and Duvernay, which I would refer the court to, that explain when you look at the totality of the circumstances, our client is faced with a very expensive, very long trial with our sole president.
That's a business decision. You don't get, if you make a business decision to settle something, that doesn't mean that you didn't get due process, that you didn't get a full and fair opportunity. I can't explain why you didn't at least seek a stay, quite frankly, and I don't know where you got the impression that we wouldn't fairly consider a stay of a trial on it where there's a jurisdictional issue to be decided. But your strategic reasons for going forward can't mean that you were deprived of the opportunity to pursue or a full and fair opportunity to be heard on the issues that you feel aggrieved you.
I feel that before my time is up, I must correct something.
It actually is up, and I'm giving you latitude, so go ahead.
Sure. And Justice Singh had raised 2 points that I'll point out in the record. They come from the Herlihy case, the issue of the pension fund. Ms. DeWachter had testified in the Herlihy case that she believed Mr. Cullen individually took that. It wasn't the South Carolina company, it was him individually, but that was speculative. And that's in the record at 893. And secondly, as to the accounts receivable, even plaintiffs admit that Ms. Walsh corrected her deposition and said that on her errata sheet that that was an incorrect statement in her testimony in Herlihy, and that was admitted by the plaintiffs at record 1585 footnote 7. Those are 2 important facts because they're facts outside the context of the contract upon which Herlihy and then DeRosiers and then Haley are all based, and they're incorrect.
And any further questions, counselors? Colleagues, forgive me. Okay. Thank you all.
Thank you.
Thank you, Your Honors.
Luis Perez Vargas against Aaron. Step up, please.
Yes, may it please the court, Richard C. Bell for the plaintiff appellant. The errors below were genuine issues of fact were viewed in the light most favorable to the movement defendant instead of the non-movement plaintiff, which is a standard without precedent. Additionally, credibility was determined by the court below. It engaged in issue determination instead of issue finding on a threshold motion where the plaintiff had prima facie evidence of 3 surgeries to 3 different body parts, objective range of motion findings, objective muscle spasm findings, causation findings.
Counselor, this is Judge Singh.
Yes.
Wasn't there a cessation of treatment here after the 3 surgical procedures?
Yes, and it was completely addressed in both treating physicians' reports. Both surgeons addressed it, and they addressed it as that any future treatment would be only palliative in nature, and that is.
What was the basis? What was the objective basis for that statement? I understand that they may reach that conclusion. Sounds a little speculative to me. What was the medical basis for the experts making that finding?
Well, as in Pommel's, where that actual language comes from, is that there's no cure. He still has symptoms, he still has pain, he still has range of motion problems. Physical therapy is palliative because it is a treatment, it's not a cure.
And would you agree that defendant made out a prima facie? Your position is, I assume, defendant did not even make out a prima facie in this case.
Because the reason, I'm sorry, Your Honor, the reason is because the defendant's own Dr. Pick, as the judge called it, substantial limitations of range of motion are found by that doctor. So I don't even think they made their prima facie findings. And as a matter of fact, what the court below did was they said that yes, these are substantial range of motion problems, but since the Dr. Pick says it's due to symptom magnification, I'm going to believe Dr. Pick and do it in the light most favorable to the movement. And that's where I believe all of the problems arise from, because it's also about the subsequent accidents that the judge talks about. Well, first of all, the subsequent accidents are contained in an inadmissible internet printout from some insurance website that doesn't even identify that there were any injuries to the plaintiff. So it's both inadmissible and irrelevant, yet the judge found that we didn't address it. There's nothing to address. Number two, the judge says, well, you didn't address the past medical history. The past medical history is actually a 2006 stroke that affected the right leg. That's not an issue here. It's a right knee tear case in one of the three injuries. And a 2013 left knee surgery wasn't addressed. The judge says, well, there is no left knee allegations in this case. And the court also said that he's going to go with the defendant's doctors saying that there's not causation here, but actually, if you look, Dr. Pick gives causation as well on all three injuries. So I am really baffled by the decision below, because it ignores that the defendant, A, didn't make out the prima facie case, and B, in all instances, the evidence was looked at in the light most favorable to the movement. Additionally, when the judge says that the plaintiff's doctors did not address the pre-existing, which I just referred to as certainly irrelevant here, this court in Lee UN versus Arca Memory Cab Corp and Linton versus Nawaz has already ruled that when the plaintiff's doctor says the causation is from the accident and the defendant's doctor says it's from pre-existing, well, that's an equally plausible cause, and by its very nature, it means that the plaintiff's doctor disagrees with the defendant's doctor. So that has already been decided by this court. I think in the court below, they've established a new rule regarding how summary judgment motions in general are decided, and that's where I believe this decision was incorrect in all respects. And even with regard to permanency, it was a matter of credibility. Our two doctors said it was permanent. It was not permanency by Dr. Pick. I don't understand why it's resolved in favor of Dr. Pick's opinion on a summary judgment motion.
Yeah, Counselor, I'm going to ask you.
Sorry, go ahead.
You can go forward with your question. Just, he's out of time, so I'll allow the question and we'll move forward.
That's okay. I'm good. I'm good.
All right. I'll allow you to wrap up since we stopped you in the middle.
Thank you, Judge. In addition, when the...
In addition isn't wrapping up. That's in addition.
In summary.
That's lawyer's summary. Thank you, Your Honor. I appreciate the suggestion. Right. In summary, this is really a case where on all levels, the decision was made with the wrong standard of summary judgment. Thank you very much.
Thank you. All right, respondent, you may proceed.
Good afternoon. If it please the court, Paul Lima from the Law Office of Sobel Pevsner on behalf of the respondent. I think what we have here is a mixed match of arguments. There's a mixing of causation and 5102. You can have causation and yet not meet the elements of 5102. And then if you mix it with, well, plaintiff says we've had 3 surgeries, well, then therefore they must meet, they must already have serious injury. That's a fallacy. And the fallacy is because for the many things that Mr. Bell mentioned, one is because not only did he have a prior significant history, which his doctors knew and never mentioned, a stroke is not just something because your right leg doesn't move. A stroke, this guy was in the hospital for 9 months. You have a 2013 surgery on his left knee. Yes, that's not a claim. It's the right knee. But there's also the issue of overcompensation. So we're dealing with injuries and 5102, and regardless of whether there's causation, what we have here is the doctors, the plaintiff's own doctors failed to give him legally sufficient a range of motion loss, which would make him qualify.
Counselor, this is Judge Singh. Counselor.
Yes, Judge.
First, let's deal with the issue of significant limitation. Okay. With respect to that issue, isn't there evidence in the record that the treating physicians opined, based on MRIs, that there were tears to the shoulder, the knee, the spine, herniations, and bulges? Wouldn't that be a sufficient basis to at least raise an issue with respect to significant limitation?
Not in this case. Normally, I would say yes, Judge, but not in this case. Quite frankly, and it's just the paperwork that was submitted does not meet the threshold, no pun intended, to get over this dismissal. You have the doctor, yes, said there was a limitation of range of motion. So there's your significant. However, it was not only did the doctor use the incorrect measures of guidelines, which is pointed out in our brief, one of them didn't even use a goniometer when they did the examination. So even if we were to look at the significant limitation, we also see that here's a man that basically said, oh, after we had these procedures, I was fine.
No. That may go to permanence. That may go to permanence, and we can address that. But with respect to significant limitation, why isn't it sufficient to the doctors to testify? Here are the MRIs. Here are the bulges. Here are the tears. There's a significant limitation.
But just because they say there are tears and bulges doesn't mean that all comes from this accident. Again,
well,
I bring it in.
They do make the causal connection. I'm not saying it does or doesn't, but they do make that causal connection. No.
Well, what happens is how the doctors come to that conclusion, and I think that's what Judge Higgett was trying to point out, which is that yes, normally that's good enough, except because they miss so much in their evaluation, it can be considered speculative and not considered.
Well, doesn't that go to weight? Really?
Yeah.
Well, it does to a certain extent, and I realize that could be contradictory to my position. But however, the case law says if it's speculative, then it's not.
But what is speculative about looking at an MRI and saying there's a tear there to the shoulder, to the knees, their herniation, their bulges? The MRIs either show it or don't show it. In response, you could say, no, the MRIs don't show it, but that's not the issue, right?
But the MRIs that they reviewed, by just saying that, you're talking about a flat, basic response. That MRI doesn't show just that there's a tear or there's a bulge. The very MRI those doctors were looking at also showed chronic degenerative disease, but not in all areas. In all areas. Therefore, it now lowers the threshold of the injury that doesn't allow him to get to what he needs to meet in 5102. And that's really the bulk of the argument here, which is that while appellant wants you to focus on causation, causation is separate. It's a mutually dichotomous argument. Just because you have causation doesn't mean you meet 5102. And to meet 5102, it's the three big ones that they're playing on: permanency, significant, and 9180. And we know there's not 9180 because he went back. He said that he couldn't work, but then and his work was as a taxi driver. But then he's getting traffic violations as he's driving. So we know that the work and his life wasn't that affected. His own testimony says that. He says that he got First of all, and I backtrack. He didn't receive his first treatment.
I don't want you to backtrack because you're out of time. So, okay.
Okay.
So you can wrap it up.
I will sum up.
Okay, thank you.
Plaintiff, first treatment was 2 to 3 weeks later, referred by his attorney. No meds, doesn't meet the 3 elements that we have here for 5102. I rest on my brief.
Thank you. All right, rebuttal, Counselor.
Yes, Your Honor. The defendant's whole argument goes to weight and goes to credibility, and that's why summary judgment shouldn't have been granted. When he talks about what the MRI showed or didn't show, they were eyeballed. There were 2 surgeries, one to the shoulder, one to the knee, and then there was a discectomy also done. In addition, when the defendant talks about the goniometer, first of all, we have De Los Santos versus Basilios, where the First Department says it doesn't necessarily have to be. It happened to be a goniometer with the lumbar, and on the second surgeon it was not, but under that case law, it was not necessary. Second, when they bring up guidelines as to the percentages of loss, I know of no case that says that's binding, and in many trials, it's subject for cross-examination because it goes to height and weight and age and factors like that. So the court clearly missed the point of its role in this case, which was to find issues and not to determine issues. Thank you very much. If there are no questions.
Thank you. Any questions, colleagues? Okay. Thank you very much, both of you. I thank you for your patience today with our technical problems, but I think we got it together nicely. And the court is now closed. The appellate division is no longer in session. Thank you.
Have a great day, everybody.